Okay. Welcome back everyone, and congratulations, you've almost made it through the first day. That last session was pretty dense. We covered a lot of different obligations. It's a lot to go through just after lunch, so thanks for sticking with me. This last session, it's a bit different. We're talking about some broader issues. So we'll be drawing on some of the things we've talked about already, looking at the scope of the services chapter, but also specifically how it interacts with other chapters. So we'll be drawing on some of that stuff that we've covered and building on it. I should say again, there will be a quiz at the end of this session. But I think everyone should be feeling pretty confident now because we've had some good results and it's looking encouraging. But there is that at the end. I mean, I wouldn't be surprised if we finish this session a little bit earlier than is allowed for in the schedule. And if that's so, if anybody has any questions, I'm sure for Martin as well, there should be time for that, for some broader discussion. But let's get into it. This one. Here we go. Okay. All right. So we're going to look at two issues of relationship here. First of all, we're looking at the relationship between the services and investment chapter. And there's a couple of key messages I wanted to set out at the start. And that's that some service sector activities are potentially covered by both the services and investment chapter obligations. And that's because of this concept of Mode 3 service supply, which Martin introduced to us. The services chapter, excuse me, applies where a foreign service supplier establishes a service sector business in another PACER Plus country. This is also a kind of investment. And so that's basically the reason for the overlap. That's the reason for the interaction. But the PACER Plus chapter addresses this relationship and has some rules about how to work out which obligations apply. Okay, so just a recap really. We've already looked at this, but the PACER Plus services chapter applies to measures affecting trade in services. And Martin has already talked about how trade in services is defined through these 4 ways or modes of supplying a service. That's how it's defined in the treaty, that's how it's defined in GATS. Now this includes a service supplied by a service supplier of one party through commercial presence in the territory of another party. So that's what we call Mode 3. What do we call it Mode 3? Just because it's the third in the list. That's why it's Mode 3. So what does commercial presence mean? Well, this is defined in the treaty to mean any type of business or professional establishment, including one operating through the constitution or acquisition of an enterprise. And if we remember back, an enterprise basically means a business. It's a broad term for all kinds of different business structures. So, to supply a service through this Mode 3 supply, to supply through commercial presence, requires the creation or the acquisition of a business in another party. You can only supply a service through Mode 3 if you create a business in that country, so you establish a company, you build a factory, or if you buy a service sector business. That's how you supply Mode 3. And so this requires investment. If you're building a company, building a business, or you're acquiring a business, that is a kind of investment. And so the services chapter does cover some kinds of investment in service sectors. So Martin's been through this just to make sure that that's clear to everyone. Mode 3 service supply. In this example, we have a foreign bank. Let's say a Samoan bank establishes a branch or a subsidiary in Kiribati. That branch in Kiribati serves customers in Kiribati. That's mode 3 service supply. The action of setting up the branch in Kiribati, that is a kind of investment. So that's really the reason for the overlap. So that's, I think the, I think the mics has dropped out. So that's the services side. Oh, thanks. Thanks, Martin. Cheers. That's the services side of the picture, but we also have to look at the investment side. Now, we're not focusing on investment today, so this is just to understand how service sector businesses might be affected by the investment chapter rules. So the key thing to know here is that the investment chapter, and this is very, very typical in investment agreements, has a very broad scope. So it applies to a whole wide range of assets and investments, and these specifically include both an enterprise and shares, stock, and other forms of equity in an enterprise. So investments that are covered by the investment chapter specifically include where a investor from one PACER Plus party either acquires a business in another party or buys shares in another party. So these are covered by the investment chapter, but as we've just talked about, ownership of a service sector business in one party by service suppliers of another party is also covered by the services chapter, because that's mode 3 service supply. So we have an overlap here. So a service supplier who establishes a business in another PACER Plus party, or who buys a services sector business in another PACER Plus party, is potentially covered by both the services and investment chapter obligations. Now that could be a bit confusing, but PACER Plus addresses this issue, and it does it in this relationship provision in the investment chapter. So the part I've extracted there is that the investment chapter does not apply to measures adopted or maintained by a party affecting trade in services. Now, for our purposes, what we're focusing on is mode 3. So if we translate that, what this means is that the investment chapter doesn't apply to rules or requirements affecting the establishment of a service sector business by a supplier of one party in another party. So that's the general rule. These are carved out of the investment chapter because they're covered by the services chapter. And so the parties have decided we will treat this mode 3 investment in service sectors as a services issue. We'll treat it the same way as GATS. That's what they've decided. And so the investment chapter contains national treatment, MFN obligations, but they don't apply to mode 3 investments. It's the services chapter, national treatment, MFN, market access obligations that apply. That's the decision the parties made. Not all FTAs take the same approach, but PACER Plus follows GATS. But there's not a complete carve-out for all requirements affecting services from the investment chapter. Some investment chapter obligations do apply to service sector investment, including Mode 3 investment. And that's because they're carved back in to apply to these investments in service sectors. And so this is also set out in the investment chapter. So the text is small, we won't worry about the details, but essentially the investment chapter includes what are commonly called investment protections for investors. Now, these only apply to existing investments which have been made in the country. They don't apply to investors seeking to make an investment. They're not market access obligations. Two of the key investment obligations include the rules around expropriation and the minimum standard of treatment. I don't think I'm going into that, no, I'm not, in any detail, but just to give you a very quick sense of what they involve, if you're not familiar with them. So expropriation is where a government might take a foreign investment, they might seize it, they might nationalise it, or they might take some other kind of action which effectively destroys the value of the investment. Expropriation can take both those forms. The minimum standard of treatment is a broader kind of protection, and it protects investors against certain kinds of unfair treatment which would cross a threshold of seriousness where it's seen as not breaching this internationally accepted minimum standard of treatment. It's a broader standard, and it takes a little bit longer to explain what it requires. But for our purposes, it's a protection for investors who have made investments. And in PACER Plus, these protections, they apply to all investments in all sectors, including service sectors. Now, another important point here is it's not only sectors where a party has made specific commitments. So it's not like national treatment and market access. A country might have no specific commitments in education services, but if the government seized a private university, for example, or if they nationalised it, then that could still be expropriation. That could still be in breach of the investment chapter because it applies to all investments. It doesn't matter whether they're specific commitments or not. Again, this is a pretty common approach in trade agreements, that the investment protections apply to all investments, whether they're in service sectors or not. That's really what I was going to cover with the relationship between investment and services. I know we're talking about the investment chapter, which people here aren't, most of you are probably not directly concerned with. Any comments or questions? Yeah, please.
Can I just ask, sorry, I just didn't really fully understand the previous slide relationship one. Can you just give an example of relationship to services and how Article 4 investment chapters in the Trevor rule applies, where there is overlap? Just an example of like.
Yeah, sure. Okay, so I think maybe I'll take a step back. So let's say we'll use an example we've used before. Say we have a New Zealand telecommunications company. They set up a subsidiary in Tuvalu to supply telecommunication services. So that's a form of Mode 3 service supply, because they are they're establishing a service sector business in another party to serve the customers in that party. So I think that's clear now to all of us that that's Mode 3 service supply, that's covered by the services chapter. But because of the scope of the investment chapter, if there was no relationship provision like this, that would also be covered potentially by all of the investment chapter obligations. Now, that's not necessarily a problem, but what it means, for example, is that we have national treatment obligations in both services and investment, and we have schedules to both services and investment, and it's possible that there could be some inconsistency between those schedules. Now, it's not surprising, but the investment chapter schedules don't say anything about telecommunications because parties have not made commitments in service sectors under the investment chapter. But there might be a question. An investor might argue, well, you haven't carved out any space for telecommunications in your investment schedules, and so you have to give me national treatment because you've committed to giving me national treatment. Now, it's not necessarily a problem, but there could be other questions. In some cases, there are slight differences between the obligations in the investment and services chapters. So the national treatment is similar but not identical. There's slightly different language. It gets a bit technical, but there could just be these questions. It's mainly an issue also for governments to have a clear understanding of where their commitments are and what they've committed to. And it's less certain, less sure if you might have committed under two separate chapters. So really the point of this is just to say, when we're talking about market access commitments in service sectors, you only look at the services chapter and you only look at the services chapter schedules. So that's the general principle. But then parties have decided, but why should we not give the same protection to service sector businesses as we give to other investments? So if we say that if a government seizes a foreign investor's factory, if we say if they do that, they should compensate the investor, then why wouldn't we also do that if they seize their telecommunications company? So for market access, PACER Plus treats these excuse me, Mode 3 investments as a services issue. For investment protection, it treats them as investments. So it's kind of a mixed approach. Hopefully does that make it clearer? Oh, thanks. Any other comments or questions about this? I know it's tricky because a lot of you won't have engaged with the investment chapter. And so you might not be familiar with some of the obligations in that chapter. It's not surprising. Just something to be aware of. I mean, really your colleagues who are responsible for investment, they should hopefully be aware of this as well. But maybe one other key message to leave you with is that these investment protections, the standard of treatment and expropriation, they apply to all investments, whether you have specific commitments or not, all investments. Okay. All right, moving on to look at the second issue of relationship, which is between the services and MMP chapter. All right, and so I know that in Martin's session there were a lot of questions around Mode 4 and MMP and the relationship, and so this will bring up some of those same questions as well. So please feel free to jump in, but we'll talk through some of the different elements, how this works in the FTA. So we've already talked about, and Martin explained going through the scope of GATS, the services chapter applies to Mode 4 service supply. So this is where a service is supplied through presence of natural persons. So where people, real life breathing people, go from one PACER Plus party, travel to another party to supply a service in person in that party. Real living breathing people. That's Mode 4. Now, that's what the service chapter applies to, Mode 4 service supply. On the other hand, the MNP chapter, the Movement of Natural Persons chapter, contains commitments to allow the temporary entry of certain categories of business people. Now, one of the key messages I want to leave with you through this presentation is that movement of natural persons, MNP, in the sense of the MNP chapter, it's not the same as Mode 4. They're not the same. And I know it's confusing because often trade officials, negotiators use all these terms interchangeably. They throw them around like they're the same thing, but they're not the same thing. And we'll look at some of the reasons why. To start with, the scope of the MNP chapter is broader than Mode 4 service supply. It doesn't only apply to service suppliers. It applies to investors, including investors in non-service sectors. They're not service suppliers. It applies to other business visitors, for example, people travelling for meetings or to set up a business establishment. So the MNP chapter doesn't have the same scope as Mode 4. It's broader. They're not the same thing. One other issue, one other key message under PACER Plus, which is different to many other agreements, is that the parties have not made any Mode 4 commitments in their services schedules. There's no Mode 4 commitments in the services schedules. Any Mode 4 commitments, if parties have made them, they've made them in a separate schedule to the Movement of Natural Persons chapter. So that's why, I don't know if you remember from my first session, I was talking about the structure and the different parts of the FTA we have to look at. If we want to understand the full picture about the commitments that the parties have made on trade in services, we can't only look at the services chapter and the services schedules. We need to also look at the MNP chapter and the MNP schedules because most parties make commitments on Mode 4 in their MNP schedules. Yeah. Please, Mame, feel free. Okay, so just tracking through, this is really just to show you where these provisions are in the text. There's the definition of trade in services in the services chapter, which includes Mode 4 service supply. Now, Martin's been over this, just to make sure we're all on the same page. This is where real life person travels from one party to another party to supply the service in that party. Okay, now, Mode 4 service supply requires people to travel. It requires migration. You can't have Mode 4 service supply without people travelling from one country to another. That's necessary. So that's one starting point. Now to look at the scope of the MNP chapter. So actually, I'll take a step back. So the trade in services chapter is concerned with trade in services. It just so happens that one way that you can supply a service is through people travelling from one party to another. So the services chapter covers Mode 4 service supply as one of the ways you can supply a service. That's what the services chapter is concerned with. Now we look at the Movement of Natural Persons chapter. These are the articles, but I'll just move on to talk about the key aspects of this. So, Mode 4 service supply, as I just said, it does require travel. It does require temporary migration. But services chapters aren't focused on migration. That's not what they're concerned with. And parties don't make commitments to allow temporary entry of foreigners in the services chapter. They don't make any commitments on temporary entry in the services chapter. They do make commitments to allow business people to enter the territory in the MNP chapter. So parties do make commitments to allow certain people to enter their country in the MNP chapter. Now, what are the objectives of the MNP chapter? Well, it's to provide rights and obligations in addition to the services and investment chapters. So it applies in addition to the services commitments. And in terms of its scope, it applies to requirements affecting the temporary entry of persons of one party into the territory of another party. So the MNP chapter does explicitly apply to requirements that would prevent people from travelling from one party to another. Now the key commitment, really the core of the MNP chapter, is the parties make a promise to allow people to enter their territory if they satisfy the conditions in the schedule. And it only applies to certain specific categories of people. It's not anyone, it's not any Mode 4 service supplier, it applies to specific categories of people. Excuse me. But they have to fit in one of the categories, and they have to meet all of the conditions, they have to meet all of the eligibility requirements, and they have to meet all of the, whatever the immigration formalities, the immigration requirements are. So there are commitments to allow temporary entry, but it's not unqualified, it's not open slather, it doesn't apply to everybody. So this is just an extract from the MNP chapter. So in their schedules to the MNP chapter, parties set out, excuse me, the categories of people where it's prepared to make these commitments. And we'll look at what that means in a second. And also set out the conditions they have to satisfy. So they're only entitled to enter the country if they fit into one of these categories and they satisfy all of the conditions. Now, to take a step back and to look at the relationship between the services chapter and the MNP chapter and how they fit together. Well, the general obligations in the services chapter, the core obligations, they apply to Mode 4 service supply. So MFN, domestic regulation, all of these commitments under the services chapter apply to Mode 4 service supply. There's no carve out for Mode 4 from the services chapter, it's not excluded. So the services, excuse me, the services obligations apply to Mode 4 service supply. But in practice, so the treaty doesn't say anything about this, but in practice, the parties have not made commitments on Mode 4 service supply in their services schedules. There is no, I'll just jump ahead for a second. So this is an example from Cook Islands, and it's just very typical of all parties. It's just an example to show you. Parties only make commitments on modes 1, 2, and 3. This doesn't refer to Mode 4 in the schedule at all. There's just no reference to it. And so parties, excuse me, don't make any Mode 4 commitments in their services schedules.
Is there any reason why?
Well, it'd be interesting if any of the parties have any views about that, but I think the reason why is because the parties chose to do it that way. Because it's unusual. So most trade agreements, the parties will make Mode 4 commitments in the services schedule, even if it's to carve out a really broad amount of space. They will still refer to Mode 4 in some way. I think in this case, well, actually it might be a bit clearer when we go through and have a look at the way it's done in the MNP chapter, but it's a decision. So parties have made a decision, and basically, just to jump forward, it's because, as I understand it from looking at the commitments, it's because parties are only prepared to make market access service commitments in categories where they're prepared to make temporary entry commitments. So only in these limited cases. They're not prepared to make Mode 4 commitments across the board for all people. It's related to some of the points that Martin made about the scope of Mode 4, and just reflects the fact that most countries want to maintain control over their immigration measures and who they admit and under what conditions. But yeah, Martin.
No, I mean, I think it is a bit unusual, the structure. There are some precedents and some other trade agreements that are like that, but there was a lot of discussion during the negotiations about, would it be for services and investment, would it be a positive list approach, a negative list approach. In the end, Pacific Islands wanted to have positive list approach, CATS type approach to the services chapter, and also have a positive list approach for investment in other sectors, which is a bit unusual. And then, everything kind of derived from that. It started from a decision from Pacific Islands to have positive list approach to services, even if there would be, in addition, chapters on investment and chapters on movement of natural persons. Often in a lot of trade agreements, when there are chapters that go beyond the more traditional chapter on services, the services chapter would be negative list based, which facilitates integration with other chapters. So in the end, it was a decision to really cater to the particular demands in the negotiations.
Thanks, Martin. Yeah, it's interesting, and I think it makes it harder to draw the line between Mode 4 and MNP. So I understand why there might be some confusion about the distinction there, but hopefully when we track through, we can help to get a bit of a clearer picture about that. But it does make it less clear because they're combined in the same schedule for most parties. So to pick up, for Basic Plus parties, commitments in the services schedule limited to modes 1 to 3, no commitments on mode 4 in the services schedule. Most Basic Plus parties, not all, do make national treatment and market access commitments on mode 4 service supply, but they do that, excuse me, in their schedules to the MNP chapter. Most parties do that, and we'll look at how they do that. So this is, excuse me, the Solomon Islands, and I think we'll just explain some of the key aspects of this. I might jump back to this slide. It might be too small to see, but this is the Solomon Islands scheduled to the MNP chapter. And in the first paragraph, Solomon Islands says, Solomon Islands commitments under the market access and national treatment obligations of the services chapter apply only in relation to the categories of people set out below and subject to any limitations set out below. So that's how it's set out, and this is a common approach. I'm just using the Solomon Islands as an example, but this is the approach that most parties have taken. So what are the implications of this? Well, I've used one example here. Solomon Islands has made commitments on this category of independent service suppliers. This is a very common category that parties make commitments on. This is a self-employed person who's supplying a service, for example, under a contract to a business in another party. So what does this mean? Solomon Islands MNP schedule commitments. Well, because the Solomon Islands has said this and set it out in its schedule, services market access and national treatment obligations excuse me, only apply to mode 4 service supply if the mode 4 service supplier is covered by its commitments to the MNP schedule. So only if it falls into one of those categories. And the commitments apply subject to any limitations they've set out in the MNP schedule. So this example, Solomon Islands does make MNP commitments to allow this category of independent service suppliers if they satisfy all the conditions. So to start with, they have to satisfy the definition, the test set out, what it means to be an independent service supplier. They have to meet that definition. They have to satisfy those conditions. Secondly, this applies to all sectors listed in Solomon Islands Services Schedule. So it only applies to services sectors where Solomon Islands has made specific commitments. It's not a commitment to allow all Mode 4 service suppliers who would meet this condition, excuse me, they have to also be in a sector where Solomon Islands has made specific commitments. And Solomon Islands sets out the conditions, so they're only allowed to stay 90 days or a maximum if the government allows under those circumstances. So these set out the limitations and the conditions around when Solomon Islands will grant temporary entry to people who fall within this category, and also where they make their services market access and national treatment commitments. So just to work through what this means, just let me see if I've got, no I don't. So say for example Solomon Islands, they have made specific commitments in the area of legal services. And say there is a legal service provider who, let's say they're an international lawyer, and the government wants to engage them for a specific project to provide a legal service, maybe to consult with the government department, maybe write a report, and they want them to travel to Solomon Islands to do that. Well, if that legal service supplier, if they meet the conditions, if they're an independent service supplier and they have this contract with a business or an entity in the Solomon Islands, then if they meet all of the conditions in the MNP schedule, Solomon Islands has said, we will allow you temporary entry, and also we will comply with our services market access and national treatment obligations. So we won't impose restrictions on the number of independent service suppliers who can come and supply this service in our country. We won't discriminate against you in relation to local service suppliers. So Solomon Islands says, yes, we will make market access and national treatment commitments on Mode 4 service supply, but only if you fit into one of these categories in our MNP schedule, and only if you satisfy all of the conditions and tests. How was that so far? Does that make sense to everyone? Everyone have any questions about that? It's tricky, I know, because the schedules are quite detailed, and we haven't spoken about schedules in detail yet. And some of the concepts. So basically, the parties have maintained a lot of control over Mode 4 service supply. In general, they're not prepared to make sort of across-the-board commitments. They are prepared to grant temporary entry to certain categories of people when they satisfy the requirements, and if they are prepared to allow them to come into the country, then they have said that we will comply with our market access and national treatment commitments for those people, but not for anyone outside of those categories or outside of those circumstances. Okay, a couple of related issues, and Martin touched on these as well, talking about Mode 4 before and the way this is dealt with under GATS. Just wanted to draw a distinction between temporary entry and permanent migration and employment. So in the MNP chapter, parties make commitments to allow temporary entry of certain categories of business visitors. Now this includes service suppliers and it includes investors, but it's temporary entry to supply a service or to make an investment or for some other business purpose. There's no commitments to allow permanent migration, no commitments with regard to people seeking citizenship, no commitments at all, because these are not seen as trade issues. Also, as Martin said, under GATS, the same thing applies to PACER Plus. There's no commitment to allow suppliers from other parties to access the employment market in the PACER Plus countries. So no commitment to allow people to come and seek a job or seek employment in the PACER Plus parties. That's seen as a employment issue rather than a service supply issue, for example. So there's no commitments to allow people to come and compete for employment under PACER Plus. One other point again, which Martin mentioned under GATS, it's very similar under PACER Plus. The MNP chapter confirms that parties have broad freedom with regard to their immigration measures, immigration controls. And so it confirms that nothing in the agreement prevents a party from imposing immigration measures subject to one qualification. It's not used to undermine the benefits of the agreement. Now, when might that be an issue? Well, if a party has made commitments to allow temporary entry in its MNP schedule. So, for example, we looked at them with the Solomon Islands. They have committed to allow independent service suppliers in sectors where they have made specific commitments in their services schedule. So, let's say again, this includes courier services. So, if the Solomon Islands decided, oh wow, there's too many couriers now, we're going to stop granting visas to foreign courier suppliers, that would undermine a benefit which the other parties would expect from the agreement, because the Solomon Islands has made a commitment. They've said, we'll allow temporary entry of independent service suppliers if they satisfy these conditions and in sectors where we've made specific commitments. So there is some impact on immigration measures, but only if they would undermine the benefits of the agreement. And so if a party has made a specific commitment to allow temporary entry of mode for service suppliers in a certain sector, if measures were introduced to undermine that commitment, then that might be an issue. But that's one of the few cases. So broad flexibility, broad freedom with immigration measures, because all countries want to have freedom with immigration measures. I think that's it. So we are a bit ahead of time, as I thought. We do have a quiz. So we've got a bit of time. Yeah, Martin, sorry.
Well, I mean, just to highlight a point, I mean, in the negotiations, I mean, it may seem a bit complex, to have a chapter on MNP, and then we have a chapter on services that covers different modes of supply, different schedules for MNP, for services. But it also was done to try to reflect the fact that for most Pacific Island countries, there was a lot of interest in MNP. And so there was an issue of importance for them in the negotiation, wanting to draw attention to it. And so that's the reason why there was a separate chapter on MNP, because that chapter includes commitments, and it also includes a few additional, transparency, procedural obligations with respect to the movement of natural persons, and that was seen as something of importance for Pacific Island countries in those negotiations, since this was an area of export interest. So it was largely at the demand of the PICS that this was included in the agreement.
Thanks, Martin. And it's pretty typical as well to have a separate MNP chapter. So it's yeah, it's quite common in FTAs to do it a bit differently to GATS. And, well, before we have the quiz, any other comments, any other questions? Anything about Mode 4, MNP? All clear? Yeah. Yep. All right then. Let's move to the quiz.
Sorry, just a quick
Oh
one.
yeah.
What
Yes.
happens when there's a state of emergency in a country and then does those rules stop? Or
Well, it would depend, I think, on the nature of the emergency. So what would be most relevant there, I think, is the exceptions, potentially. So we looked at a couple of exceptions which are potentially relevant there. So security exception, obviously, is potentially relevant. But that doesn't cover every potential emergency. So there's specific issues. The broadest limb of the security exception is emergency in international relations or war.
in Vanuatu we have a state of emergency at the moment for 6 months because of the cyclones. So
Oh, I see what you mean. A cyclone, yeah. Yes. Well, it might be the general exceptions then would be more likely to be relevant. For example, measures to protect human life or health. There's various other provisions which could be relevant. I mean, it would depend on what the response was, I guess. So, I see what you mean, but like a response to a cyclone. So do you have a measure in mind? Like a kind of, I was wondering what the government might do in response to that, which,
at the moment we've approved an emergency employment visa
oh, I see.
to support the return for workers to come and support some of the industries. And it's been open to any type of sectors to come and apply for it, for instance.
Uh-huh.
But it's only limited to 1,500, so it does not really open up to everyone, just restricted numbers.
Yeah, okay. Well, I mean, it depends in part how that relates to Vanuatu's commitments under PACER Plus, but there's nothing to prevent Vanuatu from having some kind of extraordinary visa measure to allow people to come into the country to respond to a crisis. It would only be an issue potentially if Vanuatu was restricting entry in a way which undermined the commitments you've made under PACER Plus. And that, I mean, that doesn't seem necessarily what you're saying there. Like I said, probably the key point should leave you with it. There is broad freedom for immigration measures under PACER Plus, because there always is. It depends on how countries express this specifically in their schedules, but often they maintain the ability to, for example, a lot of visas are subject to maybe sponsorship requirements, eligibility requirements. In some cases, parties make it clear these can change. The amount will stay the same. Eligibility can change. And so it depends how the commitment is drafted, excuse me, and how this action intersects with those commitments. So I think that'd be the starting point. It doesn't sound like it would necessarily offend the obligations. And then even if it did, there might be exceptions which were relevant. Yeah. I hope that's useful. All right. Any other questions, comments before we go to the quiz to wrap up the last session for the day? No? All right. Well, let's go to the quiz then. Why don't we? Actually, we're not too ahead of schedule. So we'll allow again now about 5 minutes, and then come back and just go through the responses. So yeah, if you could log on, that'd be great.